will come to order, and the clerk will please call the roll.
Chair Smithy,
Here?
Vice Chair Wu, Ms. Bowers. Here. Mr. Cook.
Here.
Ms. Jones.
Present.
Mr. Little. Mr. Louderback.
Here.
Mr. Money.
Here.
Mr. Moody.
Present.
Ms. Rodriguez Ramos. And then Mr. Verdell.
Here.
Have a quorum present. Thank you, members. Mr. Little had notified us that he was delayed in an airplane, and so he's going to join us as quickly as possible. And I'm sure we'll have some other members coming in just a moment. But we'll go ahead and get started. Appreciate you all being there. We've got a good committee this session, I think. I wanted to just kind of introduce our staff of the committee, just so you'll know them. They're going to be there to help you all as well. First of all, Sarah Kemp is sitting to my right. She's the chief committee clerk, and she'll be assisting the committee. We have Lindsey Roberts, where's Lindsey? General counsel. He's had experience considerable experience in the criminal law field. We also have Katie Irwin, who is the assistant committee clerk, and then my staff too is going to be available to the committee members and to anyone really who has issues in the committee. Andrea Stingley is the chief of staff, and Snigdha Ramanini is the administrative aide. So if you have any issues, feel free to contact them. A couple of things I just needed to mention. We have new microphones now, if you haven't noticed. And when it's red, it means it's not working. It has to be green to be on. And also, I've been asked to tell you that you have to speak directly into the microphone. And purpose of that is not to pick up clutter in the background, so that the audio that's going out and the recording is more clear, where we have information we need to have as opposed just to noise and conversation that is to the side. So those two things, just make sure your green light is on and also that you're speaking directly into the microphone. Today we called a number of witnesses, 11 I think, actually 8 witnesses from state agencies. These are state agencies only. Next week we're hoping to maybe have some more introductory or organizational type witnesses to kind of familiarize us with some of the aspects of the criminal justice community, as well as bills next week. We're finally getting bills referred into the committee, and we'll be hearing those next week. So we're going to call the witnesses today in three-person panels. And so what I think the most orderly way to proceed would be to let each of the 3 witnesses give their statement that they have to the committee, and then we'll open it up to questions from the committee members, if that's okay with everyone. And I would just say that we've asked the witnesses today to kind of limit their testimony to 5 or 10 minutes, not to take a lot of time. And certainly you're free to ask questions, but if you've got a lot of questions, or if you want to get more in depth, I think any of these witnesses today would not only be willing, but would welcome the opportunity to visit with each committee member. And I would urge all the committee members to get to know these witnesses, because most of the bills that we deal with will involve them in one way or another, and they have a certain degree of expertise on the subject matter. So if there's nothing else to touch on, I was going to go ahead and call up panel 1, and it's the Texas Department of Criminal Justice, the Texas Board of Pardons and Paroles, and the Texas Indigent Defense Commission. And I would just remind everyone who comes up that hopefully you've signed the electronic witness affirmation, and we would ask that you do that. And we also would ask that you, when you begin testifying, that you identify yourself by name and the position that you hold. We're missing one. Is anybody from the Indigent Defense Commission here? Okay, great. Oh, you need to register too, okay? She'll assist you. Yeah, we got to get you to register before you testify. We'll wait just a second while you.
Okay.
In fact, I'll go ahead. I'll go ahead and call the representative from Texas Department of Criminal Justice.
Yes, sir. Good morning, Chair, members. I'm Bobby Lumpkin with the Texas Department of Criminal Justice. I serve as the Chief Operations Officer for the agency. And this morning, I'll do a quick overview of the agency with this handout. First off, Mr. Brian Collier, our Executive Director, sends his regards. Unfortunately, he was not able to be here this morning, so I will cover our overview. The slides you see in front of you, first, the responsibility of the Texas Department of Criminal Justice, of course, is the operation of our state adult prison system, as well as the adult probation supervision system and funding for the adult probation system. Even though probation is operated at a judicial level, their funding and oversight come through TDCJ. Oversight of our agency comes from the Texas Board of Criminal Justice, composed of 9 non-salaried members that are appointed by the governor with advice and consent from the Senate, and they serve staggered 6-year terms.
Let me interrupt you. Does everybody have a copy of the handout?
Looks like this right here.
It was handed out. It should be just on the regular table.
Yeah, it should be under your stack of papers somewhere.
You actually have
we'll try to
a two-sided one-pager.
Yep, we'll
but
try
I'm
to get
gonna
those
present from
distributed.
this.
Make sure everybody's got them. Go ahead, I'm sorry, I didn't mean to interrupt.
No problem.
Yeah, go ahead.
Sure, okay. First, I'll cover the prison system's current snapshot of where we're at. Currently, we have 102 facilities across the state of Texas with a population of 135,537. Within that, we also have some idled facilities and idled beds in some areas that are rural and hard to staff. We have 3 units that have beds dedicated to Operation Lone Star. Current LBB projections show a progressive growth throughout the rest of this year into 2026, but with those idled beds, we can support that growth for the rest of this year and through next year. Our correctional officer staffing today stands at 80.2% filled of our correctional officer ranks. We currently, in our exceptional item and introduced in the introduction budget, was a 10% pay raise. Thank you for that start. Our current staffing shortage is 4,807 officers short. As a reminder, in April of '22, we hit our high water mark of over 8,000 officers short. So we have shown some improvement in recruiting and retention and down to a current number of 4,807. Certainly still need to improve that number, but we have seen gains in correctional officer staffing. Moving to population demographics and profile. First, to point out that our average age of adult offenders is 42, with a gender breakdown of 92% males and 8% females. One thing not on this slide, but we like to point out, is our over 55 population and mental health. First, our over 55 population, which if Mr. Collier was here, would tell you that's not owed, and I would tell you as of this year that's not owed. But our population that comes in from the jails, you see their physiology age is 10 years higher usually than what they are, so we rate that at a 55 age. With that, 23,000 plus are 55 or older. That's a 34% increase in the last 10 years. Moving to our mental health population, we have a population of 37,000 that range anything from inpatient that you may see also in a state hospital to some type of caseload, case management, medication type mental health caseload. That, again, is 37,000, and we've seen a 50% increase over the last 10 years. Our population profile, our violent offenses of both state jail and in our ID are at 64%, education level at a 7th grade. Moving to adult probation, as I mentioned earlier, operated at a judicial level, but of course their funding and oversight comes from the agency. We provide that funding and oversight and training to the 122 community supervision and corrections departments. Those departments have 2,600 plus probation officers across the state. We disperse the funding, develop standards, provide training, conduct evaluations, and maintain statewide data. Currently, that oversight is of 246,000 probationers across Texas, 164,000 are felony probationers, and 77,000 are misdemeanor probationers. Moving to parole supervision, we provide parole supervision for those released approved by the parole board on parole or mandatory supervision. As you'll hear in a little bit, the parole board is a separate entity. We supervise the released individuals as they serve out their sentences in the Texas communities, ensuring that their activities of release and their compliance with the conditions of release. Currently, we have 67 district parole officers across the state with 1,149 officers and currently 75,000 on active parole. Last slide is Interstate Compact. I'll quickly cover. Interstate Compact is an agreement among states and also has rules that you can actually transfer probation or parole supervision to another state and have that person supervised in that other state that you have the agreement with. This, of course, occurs when an individual that is arrested in another state versus their home state then has their supervision transferred back to their home state. Currently, we are in our agreement with other states, we have 4,800 probationers and 2,100 parolees from other states supervised in Texas, whereas over 8,000 probationers and 2,300 parolees from Texas supervised in other states. We're in agreement with the Interstate Commission for Adult Offender Supervision, which sets standards, and this commission helps us work through these processes. With that, I will pause for any questions.
Thank you, Mr. Lumpkin. We'll move on to the next witness, and then if the committee has any questions.
Yes, sir.
And we understand that we have a committee on corrections here in the House, and they do most of your oversight, but it's still you're inextricably intertwined with the criminal justice
Absolutely.
system, obviously. So
Yes, sir.
we're interested. Okay, our next witness comes to us from the Board of Pardons and Paroles.
Good morning, Chair Smithy and members of this distinguished committee. My name is Marcia Mobberly. I'm Chair of the Board of Pardons and Paroles. We appreciate the opportunity to present and participate in this organizational meeting. We have provided a handout in advance for your convenience. It's a small handout. I'm hopeful that everybody has that. We would like to give you a brief overview of our agency and are open to any questions that you may have. Additionally, over the course of the legislative session, please know that we will be available to meet with any members or your staff and to testify on matters before this committee as a resource. The mission of the Board of Pardons and Paroles is to determine which inmates should be released on parole or discretionary mandatory supervision. It is important to remember that the board does not determine initial eligibility. The statute, as developed by the legislature, determines the time that must be served on each offense before becoming parole eligible. If a decision is made to release an inmate, then the board also sets the rules of conditions of release. Most individuals have the same general rules, such as reporting as instructed, not moving without permission, and obeying all state and federal laws. Additionally, we impose special conditions that are tailored to each person, such as an interlock device for an offender that has been convicted of a DWI. Once released on supervision, the offenders are supervised by the Texas Department of Criminal Justice Parole Division, not the board. Violations of parole, however, are brought to the board for resolution, and we have several options to address such violations, including parole revocation. And finally, we review and make recommendations regarding clemency to the governor. The board consists of 7 board members appointed by the governor and 15 parole commissioners hired by myself. These voters are in 7 offices throughout the state. Most cases are determined by a parole panel of 3, where a majority is required to either grant or deny parole. There are certain extraordinary cases that by statute only board members can review and vote. There are These are particularly egregious offenses, such as aggravated sexual assault. Additionally, the board has numerous other offices and departments that support our operations, such as our institutional parole division, hearing operations, and clemency. In total, we have roughly 500 FTEs. We are the largest paroling authority in the country. As you can see from the chart we did provide, we consider over 64,000 cases for parole and nearly 15,000 cases for discretionary mandatory supervision in FY 2023. Our approval rates have varied over the past decade between 35 and 40%. Over the years, the legislature has recognized the importance of rehabilitation programs and have made funding available to such programs. It is important to point out that our board often requires successful completion of a treatment program prior to the release on parole. We have also included recidivism rates as determined by the Legislative Budget Board, and this rate has declined substantially over the last 15 years. While we are always looking to improve our operations, I do believe that this is reflective of the good decisions that our board is making. In closing, we recognize the success of parole in our great state is dependent upon the Texas Department of Criminal Justice and the parole board working together. We have forged a tremendous working relationship that focuses on successfully reintegrating offenders back into society, with public safety being a top priority. Thank you, committee, and thank you, Mr. Chair, for the opportunity.
Thank you, Ms. Moverly, for coming this morning. We appreciate it. And so our final witness on this panel will be from the Texas Indigent Defense Commission. Mr. Ellis, appreciate it.
Thank you. Thank you, Chairman Smithy, members. I am Scott Ehlers. I'm the Executive Director of the Texas Indigent Defense Commission. I have some materials for each of you that's being passed out right now to give you a little background on indigent defense, as well as your districts in particular. I've got a district fact sheet there for each of you, so you know what's going on in your district and how the Texas Indigent Defense Commission is helping your counties or counties. So thank you for giving me the opportunity to tell you a little bit about the Texas Indigent Defense Commission and the state of public defense here in Texas. TIDC protects liberty and families by ensuring Texas and its 254 counties provide an attorney to people who are required to receive one according to the U.S. and Texas constitutions and Texas statutes. TIDC funds, oversees, and improves representation in adult criminal matters, juvenile delinquency cases, and family protection representation, which is provided to parents and children in Child Protective Services cases. TIDC got its start in 2001 with the passage of the Fair Defense Act, and at that time we were called the Task Force on Indigent Defense. In 2011, the legislature changed our name to the Texas Indigent Defense Commission and also gave us our own legislative appropriations request authority and separated us a bit from the Office of Court Administration in that regard, but we are still administratively attached to OCA. Up until 2023, TIDC was only involved in criminal and juvenile delinquency matters, but last session, legislation was passed to give TIDC authority over family protection representation, or once again, that's parental and child representation in Child Protective Services cases. We are governed by a 15-member board that is made up of a combination of gubernatorial appointees, lieutenant governor appointees, a speaker appointee, ex officio members like the presiding judge of the Court of Criminal Appeals, Chief Justice of the Supreme Court, as well as the chair of the House Criminal Jurisprudence Committee. Welcome, Chairman Smithy, to TIDC's board. Since this is your committee's organizational meeting, I thought I would provide a brief explanation of how indigent defense system works in Texas, if you're arrested in Texas for an offense for which you can be incarcerated, Class A or B misdemeanor or any level of felony, then you are entitled to have the court or the court's designee appoint a lawyer to represent you if you cannot afford one. In most counties, the judge who's overseeing the case appoints a private lawyer from a list the judge maintains of lawyers who apply to receive appointments. This is called the wheel system or assigned counsel. Increasingly, more Texas counties, especially rural counties, are using a public defender office to provide representation to criminal defendants. If you look at the backside of the first fact sheet that I gave to you, you will see a map of the 75 counties that are covered by the 28 public defender offices in Texas today. That does not include the 175 or so counties that are covered by the Regional Public Defender Office for capital cases, which is providing representation in death penalty cases around the state to rural counties, primarily in some mid-sized counties. Public defender offices have proven to be an effective way to help rural counties by ensuring that an attorney is in court when they are needed, helping the court to effectively manage their caseload. No longer do judges, prosecutors, and court staff have to wait around for a private attorney to travel hours from a city to get to a rural docket. Rural regional public defender offices are attracting new lawyers to rural Texas, and they are also helping improve quality by providing mentorship, training. They provide a salary and benefits, which attracts new lawyers to rural Texas, because as you can imagine, it's a very daunting task to start up a new law practice, particularly if you're going to rural Texas and you may not know anybody. So we view regional public defender offices for rural Texas as a good solution for them, as evidenced by the map with the many counties. The other means of providing counsel here in Texas is through managed assigned counsel programs. They are similar to public defender offices in that they have a centralized mechanism of providing counsel and training to lawyers. The big difference, however, is that with managed assigned counsel, the lawyers are all private lawyers. And the managed assigned counsel program is in charge of appointing counsel, paying counsel, providing investigators or social workers to those private lawyers, training, mentorship, et cetera. And then the other means of providing counsel in Texas are through contract defenders, which occur in a number of rural areas or mid-sized counties primarily. The biggest challenges that Texas faces today, the biggest challenge is the rural attorney shortage crisis. Last session, the legislature directed TIDC to conduct a rural public defense needs assessment, which we did through the Texas A&M Public Policy Research Institute. And I have a copy here in case any of y'all would like a copy at some point. And so what PPRI found was that the rural attorney shortage crisis is real. Rural counties have lost about 27% of their lawyers since 2018, I believe. That comes down to about 500 fewer attorneys serving Texas. So TIDC is addressing this in a number of manners. One, most prominently through our grant program, we provide ongoing 2/3 funding to rural regional public defender offices. Those are counties of 100,000 population or less that are serving 3 or more counties. At this point, we've have some really big offices serving lots of counties. For example, up in the Panhandle, we have the High Plains Regional Public Defender Office has just started up, and that's serving counties around the Lubbock area. That serves 13 counties. We have an office out of San Angelo that's serving 12 rural counties around there. So that 2/3 funding is really helping counties a lot, and we've seen a big interest by other counties in establishing more regional public defender offices. Unfortunately, we are facing significant finance shortages, and I hope you take a look at another fact sheet that I've given you about our legislative appropriations request. We're facing some shortfalls in our general revenue dedicated account that we would like restored. We're seeking $35 million to build more regional public defender offices for rural Texas, as well as helping out the urbans and the mid-sized counties. And so that attorney shortage crisis is the biggest thing that we're facing right now. We're also going to attempt to address that through exceptional item 2 in our LAR, which will build a pipeline program at TIDC for paid internships, fellowships, and loan repayment for attorneys serving high needs areas. So those are the problems that we're facing right now. I understand that y'all are not the finance committee. However, I hope some of you do take that in mind when you get a chance to vote on the budget. In terms of what will be coming through this committee that we are working on, you will see in your packet a 2-page summary of TIDC's omnibus bill. And TIDC's board is authorized by the legislature to propose improvements to the indigent defense system. And so we have a omnibus bill that just got back from Ledge Council yesterday, so should have a bill number today or tomorrow. And that hopefully will be coming through your committee to consider as well. Thank you. Happy to take any questions.
Okay, thank you, Mr. Ehlers. And you're right, this committee has no money and they haven't entrusted the committee with any money. So I'll go ahead and open it up for questions, members, if anybody has any. Yes, sir, Mr. Riddell.
Can I ask each one of them a question?
Yeah,
Is that
sure.
all right? Okay, I have a couple questions. One, real quick, was on the misdemeanor probation, is that paid for by the county level? Can y'all hear me all right like that? All right. Is that paid for at the county level, or does the state pay for the misdemeanor probation?
We
So-
fund the counties. There's local fees, but we also fund the counties for 180 days.
Okay, roger
So
that.
just for our record, when you're addressed a question, before you answer, if you could identify yourself, just so we'll have it on the audio record.
Appreciate that. Yes, sir. Next one, you had mentioned recidivism has gone down drastically since 2015. What did you attribute that to?
In my opinion, I believe it's the
Tell us
funding.
who- tell us
Oh,
who-
sorry. Marcia Mobberly.
It's first day, so.
Board of Pardons and Paroles. In my opinion, it's the funding that the legislature has provided for treatment programs, rehabilitative-based services.
Okay, all right. And then last question was for you, sir. Well, actually, it's not a question. It's I have a bill I'd like to talk with you later about, so I don't want to put you on the record for, but it has to deal with indigent service. Am I saying that right? Indigent services regarding a path towards, I think, that would be interested to talk with you about. And I'll just leave it at that. So I
Great.
appreciate y'all. Thank y'all.
Would happy to.
And I assume that each of you have visited with some of the committee members and would be more than welcome to talk to any committee members who have questions. All right.
Thank you, Chairman.
Any other questions? Yes, Mr. Money?
My question was the same as Mr. Riddell's, but I'll drill down a little bit. On the recidivism rate, there we go, basically being cut in half in 15 years, which I think is pretty impressive. And you said that the legislature has allocated some taxpayer funds for programs. Do you have any tracking on which programs those are, and this may be a TDCJ question, but and the effectiveness of each one, or what kinds of things tend to be attributing to it? Because I think that's pretty impressive.
Thank you. Again, Bobby Lumpkin, Chief Operations Officer for TDCJ. And so attributed to the recidivism reduction would be an increase in our programs through the Wyndham School District, vocation programs, programs with our college programs, and other like programs. We do have numbers that can back up some of those programs, and we can share that with the committee or with the office if you'd like us to follow up with you. But there has been more robust programs grow through the years, some through funding from the House and Senate to support that. but there is a larger inventory of programs than there were 15 years ago that do impact recidivism.
So on that same note, the parole board has Marcia Mobberly, Board of Pardons and Paroles. So the parole board has board-voted programs that we cooperatively discuss and agree to with the Texas Department of Criminal Justice. And so a lot of that is contributed to those parole-voted programs that are available. It's a cooperation, but we feel like it's coming from good decisions and good programs and good reentry.
Ms. Jones?
Good morning. Thank you for presenting. Quickly, Ms. Mobley, is it Marbley? Morbley.
Mobberly.
Mobberly. I will try to do better the next time. Do you have any numbers, like for the people that come up for parole, like what percentage make parole? And let me just give you this. I've been practicing criminal defense for 30 years, and I'm actually on the wheel sometimes. So I'm just curious.
Absolutely. We're currently, Marcia Mobberly, Board of Pardons and Paroles, we are currently at around 40% approval rate. In the last 5 years, it's floated from 35 to 40%.
And for the percentage that don't make it, like what are the reasons that they're not making parole?
Perhaps time served, perhaps the nature of the offense, the level of offense, the number of offending behaviors or times to prison, criminology factors.
I'd be, if you could get me, you don't have to give it to me now, the criminology factors, I'd like to know what that is.
Okay, thank you.
Okay. Okay, so how do we pronounce your name? Ehlers?
They all work, but Ehlers.
Ehlers, I was wrong on all accounts. Okay. Question for you. So did you say with the managed assigned counsel that they pay for it for like investigators and things? Sort of, is it like that in Harris County?
Yes, Scott Ehlers, Texas Indigent Defense Commission. In Harris County, the misdemeanor courts have approved a managed assigned counsel program, but the felony courts and the juvenile courts have not.
Because I was about to say, I've got to go to the judge ex parte if I want to try to get an investigator or forensics expert for my court-appointed cases.
Correct.
Okay.
You
all
don't,
right.
if you have a managed assigned counsel program, we have definitely found that they improve the use of investigators because, as you mentioned, there's a bit of a hassle going in order to get an investigator. If you have to go through the judge, there's probably some divulging of information that you may not want to divulge to the judge. So the MAC serves as a entity that will appoint investigators to the attorney so that they do not have to go through the judge for that approval.
And I've also noticed that with the PDs, because we have, I guess, a hybrid
Correct.
in Harris County, with the PD, they have all that in-house,
That is correct.
right? So the PD's office has everything with me, because I can't work for nobody. I got to work for myself.
Right.
Got way too much personality.
There are MACs too, like in
it's-
Lubbock, they have investigators on staff at the MAC that private lawyers can use. But most of the MACs are appointing an investigator for the private attorney.
And I know that sometimes I have law license, will travel across Texas. And so in some rural places, they'll try to get me to come down and be, to represent people. So are you telling me, not that I have any loans, but you're telling me that there's some mechanism where lawyers, I guess in urban areas, could be somehow have their loans forgiven if they go practice in rural areas? Did I hear you say that?
We are, one of our legislative appropriation requests, exceptional items, is to establish that program. So It's not for real right now, but there will be a portion of our omnibus bill will have that loan forgiveness program built into the bill, and then we are also asking for funds to fund the program.
Sounds like a good bill to me, because I know I don't like driving up the road and not getting paid, and it takes me away from cases here, so there may be some value to that. Thank you.
Thank you, Representative.
Any other questions? Mr. Louderback.
Mr. Chairman, thank you. Mr. Lumpkins, Ms. Mobley, Mr. Ehlers, appreciate the job you do, very vital to the criminal justice system. I have a question for you, Mr. Ehlers.
Yes.
What is the shortage of criminal defense attorneys? Is that a statewide issue that's going on? How do we want to address that?
Yes, Scott
Is it
Ehlers.
just a money issue that usually comes about in this building?
Right.
But, your
Scott-
thoughts?
Okay, thank you. Scott Ehlers, Texas Indigent Defense Commission. It is not only a Texas problem, it's actually a national problem. But in Texas, the few things that we are doing, you're right, in part it is a money issue in that we don't have the funds right now to meet the demand of rural Texas in terms of building. And when I say building, it's really about staffing, for the most part, regional public defender offices. And as I mentioned, that model has proven effective for a few reasons. One, it locates lawyers locally with an institutional office rather than relying on private attorneys to travel many hours, many times, as Representative Jones had mentioned, when she sometimes goes out to rural Texas and they try to get her on the wheel. So a lot of times rural courts are waiting around because, a lawyer, they have to make money, and so they're going to have most of their cases probably in the big city, and then they'll come out every once in a while to a rural county to serve that county. So with regional public defender offices, we have a local solution. People living locally, they are at court when the judge needs them. They don't have to, the judge doesn't have to get on the phone and someone, a couple hours later shows up. They are there, every day, day in and day out. So as I mentioned, there's also advantages in terms of attracting new lawyers to rural Texas with that model, in that if you have a salary and benefits, you're more likely to attract them. It's hard to start up a new practice from the get-go. In terms of the money, we are, our fourth exceptional item request is seeking $35 million to, help infuse even more funds into rural Texas, other high needs areas of the state that are lacking attorneys. And the other thing that I mentioned was the pipeline program that we're trying to establish, paid internships, fellowships, and the loan repayment for high needs areas. We have found that if you can get law students to come out to rural Texas to be able to practice through an internship at that office, they can see how great it is. And, that attracts them to work in that office afterwards. The fellowships are designed to provide a job during this gap period when attorneys or new law students, graduates are coming out of law school. They don't have a license yet. A lot of offices can't hire them during that time. So that's what the fellowships are for. And as I mentioned, a loan repayment program as well.
Thank you. One last question. The regional public defender offices, is that a path forward, yes or no?
A path forward, absolutely.
Okay. Thank you, Mr. Ehlers.
Thank you.
Chairman.
Any other questions, members? Okay. Ms. Jones?
I've got a question. With these regional public defender offices, are you going to be providing investigators as well? Because one of the problems I've found with judges, they really want to know why we're working hard for people who don't have any money, and they want quick pleas. And what I've tried to show people who aren't familiar with this is if you get a lawyer on there and we have access to investigators, a lot of times we'll tell our clients, dude, they got you dead to rights. So let me work something out for you so we can get you down the road. as opposed to the perception that we're trying to like just get people off. Now, let me be clear, I believe in the Constitution. If the state can't prove its case beyond a reasonable doubt, I'm happy to show that they can. But a lot of times when you have these resources, you can talk some sense into some people who are just trying to game the system.
Right. Yes, regional public defender office that we are establishing has built-in investigators as part of the defense team that's there. Oftentimes, there's also someone with like mental health training as well. And so, to your point about saving resources, if you've got somebody there who understands mental illness and that is their specialty, then they can help get that person into services that otherwise, a lawyer may not, that's not their job a lot of times, or they may not know what resources are out in the community. But if you have someone in the office who knows those resources and can get them into those resources, then hopefully stay out of the system going forward.
Mr. Cook?
Just one quick question. I guess it'd probably be for TDCJ. As far as the recidivism attachment that we received from pardons parole, it goes through 2019. It says it's just under 15%. Is that still, we still at that level 5 years later?
Bobby Lumpkin, TDCJ, we're at 16%. The 15% from 2019. Last year's number showed actually around 14, which probably was COVID-driven.
Okay.
Pre-COVID, we were at 20%, but currently at 16.
Perfect. Thank you.
One more. Oh, you can go.
Mr. Burdell?
Your turn.
So, Mr. Ehlers, the one question: do the public defenders do they have to have a track record of success before they get appointed, or is it just trying to put a warm body in that position? I don't mean that in a derogatory way. Just because you hear a lot of negatives about public defenders, and I'm wondering if there's like some kind of metric that they have to meet to justify that they're good at what they do.
I will admit that it's like any other occupation or office, government office, right? There are good offices out there, and there are not so good offices out there. The advantage of starting up the new offices with us is we do planning studies ahead of time. We map out what those offices will look like in terms of how many staff they need, what kind of resources they need. They will meet, TIDC has caseload guidelines, so we build those offices based on a staffing model that follows our guidelines to ensure that those offices and the attorneys and their staff don't have crazy caseloads. But there are, some offices that have been around much longer before us even we don't have any authority over those offices if they are not receiving grant funds from us. That is really the only authority TIDC has is to remove grant funds from a county. And so, at this point in terms of whether it be private counsel or public defender offices, if they are not receiving grant funds from us, then, within, the ethical guidelines that they're supposed to be following, they can really, practice in the way that they would like, and we have little authority over them to do a whole lot. But with these regional public defender offices that we are establishing, because we are providing 2/3 of their budget for all the cases that go through them, we have that authority over that office to ensure that they are following the caseload guidelines. If we hear there's problems at the office, we can step in and say, hey, you need to fix this. So we do have a lot more input from the get-go and ongoing operational support for those regional public defender offices.
Roger that. Thank you. Appreciate it.
Thank you.
The record needs to reflect that Vice Chair Wu has joined us. Thank you. Appreciate you being here. And Mr. Money has a question.
Last question for Mr. Ehlers. You talked about a rural attorney shortage. I would like to see that report. I'm an attorney in a rural area. I see that. I don't practice in criminal law, but there is a rural attorney shortage. So is that, you said that's a statewide or even a nationwide problem?
Yes, it is. As I'd mentioned, rural Texas is down about 500 attorneys. I'll correct myself. It was between 2014 and 2022. So I think, we've even lost more attorneys since then. But yes, it's a Texas problem. It's a national problem. And, because of that, we've put into place these various solutions that we are talking about. I'm happy to share this report with you because it does, I think, a great job of really drilling down on the challenges that rural Texas is facing.
So this probably goes beyond the scope of your work or even this committee, but I would just say that one of the issues is if we're seeing a shortage, it's most likely that we're going to see that shortage most acutely in the lowest paying parts of that industry, which would be public defenders, I think across the law. And I think that what you're probably also seeing is that as law school cost inflation rises, people come out of law school unable to even pay their loans back with the lowest. And so I would just like to see the legislature, in addition to, or maybe instead of pumping more money into the system, doing what it can do to increase the supply of lawyers. Not too much, because I got bills too. But look at ways that we can get more people into the profession at a reasonable cost, so that we can fill the need across Texas. And there are a lot of people that would probably enjoy doing that kind of work, but they just don't feel that they can financially afford to do it because they come out of law school with hundreds of thousands of dollars in debt. And so, anyway, that, like I said, it's beyond scope of this committee, but there are answers and solutions beyond just taxpayers paying those people more, because that's just going to deplete a different area where we also need lawyers in landlord-tenant issues, in wherever. So
Absolutely. Those, I totally agree.
Any other questions? Okay, thank you, panel, for being here. We really appreciate you and look forward to working with you this session.
Thank you.
Members, our next panel will be the Office of Attorney General, the State Prosecuting Attorney of Texas, and the Office of Capital and Forensic Writs. And once again, I would just remind you to identify yourselves, if you would, before you speak, so we can keep our record clean. I think Mr. Reno's here from the OAG office.
Yes, sir. Josh Reno with the Texas Attorney General's Office. On behalf of your Attorney General, Ken Paxton, thank you for the invitation to be here. I see a lot of familiar faces, but see a couple new ones. So if you've heard kind of this spiel before, bear with me. I'm the Deputy AG over Criminal Justice. I oversee our Crime Victims Compensation, or Crime Victims Division. I also oversee our Criminal Prosecutions, Election Integrity Division, Human Trafficking, Transnational Organized Criminal Crime Division, as well as our two law enforcement divisions, which is Criminal Investigations and our Medicaid Fraud Control Unit. The way that our divisions operate is that on the lawyer side of the shop, we have to have some type of invitation from a county or district attorney to come in as a special prosecutor, or we have to be appointed as the attorney pro tem for a particular criminal matter. The law enforcement division, we operate with an invitation to help out some of our local entities who may need some assistance, and we do that in a variety of different ways, both on the lawyer side of the shop and the cop side of the shop. We can come in and take over completely if the case wants to be, if they want to hand it over to us. We can assist in a myriad of different ways, and so we're pretty good at kind of stepping into the background if we need to, or stepping to the forefront as needed. Our Crime Victims Compensation Fund is Well, it's doing well. We're trending in the right direction. I'm happy to tell the committee that we paid out $8.3 million at the close of February. Our criminal prosecutions and our criminal appeals division are both growing. We're seeing an influx in cases since the law changed a few years ago, with more appointments for coming in as the attorney pro tem. Within the criminal prosecutions divisions, we also have the juvenile crime intervention team, which focuses on juvenile gang training throughout the state of Texas. Our human trafficking and transnational organized crime division combats human trafficking through criminal prosecutions, civil investigations, community outreach, training, and policy efforts. We've really had a focus and push the last year or so with our civil enforcement, and we have reached out to owners of properties to inform them that they may be having some tenants who are operating an illicit massage business. We inform them of that and use some enforcement actions in order to follow up and make sure that those businesses are getting shut down. Again, happy to work with this committee. Appreciate the invitation for being here, and look forward to working with each and every one of you.
Thank you very much, Mr. Reno. And then we have Ms. Soul from the State Prosecuting Attorney's Office.
Good morning. Thank you for having me here. I'm Stacy Soul, the State Prosecuting Attorney. I have a handout which y'all should have. And I'm just going to go briefly give an overview of the agency. Our jurisdiction is primarily before the Texas Court of Criminal Appeals, which is the highest court for criminal law matters. The office can exercise discretionary authority to enter into a case while it's still in one of the intermediate courts of appeals, and that's 14 of them. We don't count the 15th court because they don't have any criminal jurisdiction. And right now, we're representing the state in 28% of the pending petition for discretionary review cases before the Court of Criminal Appeals. On the next page, that is 3 attorneys are doing that amount of work. 3. We are the smallest state agency. So for executing our duties, what we do is monitor all of the reversals or anything negative for the state that's coming out of the intermediate courts of appeals. We review that decision, take a look at it, and decide whether there's an issue that should be taken up to the Court of Criminal Appeals to be settled. We'll typically reach out to the local office, the prosecutor's office, and coordinate with them on either strategy or who's going to do the petition. And then we file the petition. And so these are discretionary, that it's not a matter of right. So you really do have to convince the court to grant. And we generally have between, I would say, 30 to 70% grant rate. So we really know how to speak to the court. That is our expertise, is their jurisprudence, and how to address them and how to persuade them to grant reviewing cases. After that, we typically will file the brief if the case is granted, and then we'll present oral argument if the court grants oral argument. So we really we're very selective about the cases that we choose. We want it to have statewide jurisprudential impact. We don't really get involved in anything that's fact specific. I'm going to turn to the next page. Some cases that are in our pipeline right now. One that's caused a lot of talk, especially over in the legislature, is ex parte charrette. And this is going to be on rehearing. The court issued an opinion back in October. The court granted rehearing, my motion for rehearing, in January, sorry. And so that's whether local prosecutors, whether an offense, certain offenses within the election code have to be exhausted before the Texas Ethics Commission, before a local prosecutor can even prosecute the case. And so, of course, I filed for rehearing, saying that that's completely inappropriate. The case will be argued next month in Laredo. The court is doing an on-the-road argument there. As part of sort of its outreach with local students. We're going to be at TAMU. So that's what's coming up in the pipeline. The other case, Armstrong, I'll just point to, is about an exigency requirement for Article 1403A1, which is the suspicious places. This is something that impacts officers every single day. They need to know what elements they need to meet to fall within these statutory exceptions. On the next page, we also support local prosecutors by routinely giving advice on legal questions, linking them to valuable resources, helping them draft documents, even ghostwriting some documents in some cases. We also provided the case summaries of all the pending petition for discretionary review cases that are before the Court of Criminal Appeals right now. As far as our community contributions and sort of bettering the profession at large, two of my attorneys are on the State Bar Criminal Pattern Charge Committee, and I serve in leadership on the State Bar Criminal Justice Section Council. And we've been making a huge effort to go around Texas, go to schools, and get law students interested in the criminal justice field. And now we've even added another component on to bring in paraprofessionals. And so when we're in Laredo, along with the court, we're going to do a whole paraprofessional outreach program while at TAMU. That is all I have as far as a broader overview. I'm always happy to serve as a resource for you. And if there's anything more specific, I'm happy to come to your office and talk about it. Thank you.
Thank you, Ms. Soul. And also, the next one will be Benjamin Wolf with the Office of Capital and Forensic Writs.
Thank you, Chair Smithy, members. We're a public defender office with a unique and important mission. We serve as the Office of Conviction Integrity for the state of Texas, and through post-conviction representation, we serve to ensure that convictions and sentences are constitutional, reliable, and free from flawed forensic science. I've led this office since the Court of Criminal Appeals initially appointed me in 2015, and in this role I benefit from the wisdom and guidance of an oversight board as well. We have two basic programs: capital post-conviction representation. In this program, we represent approximately 70% of persons sentenced to death in their initial capital habeas proceedings, in addition to cases in other postures. And our second program is forensic science representation. We represent folks in a smaller number of non-capital clients who are incarcerated on the basis of flawed forensic science in cases referred to us and vetted by the Forensic Science Commission. The only claims that we litigate are constitutional claims, like actual innocence, false testimony, due process, ineffective counsel. And in death penalty cases, this review is mandatory. It's also essential. When our focus is on getting things done right the first time around. In effect, we also look to see what might have been missed, whether there are people who are incarcerated or under a sentence that shouldn't be. We investigate our clients' cases so that Texas courts may fairly evaluate whether there are constitutional issues associated with a conviction or sentence on the front end as soon as possible, not decades after the fact. And when they need not look far for examples of cases where troubling claims are being raised decades after the fact. Last year, the Court of Criminal Appeals granted relief to two separate OCFW clients. One had been on death row for 37 years, and before OCFW learned of his case, he had been largely forgotten by the criminal justice system. The other had been there for 16 years and had 3 prior execution dates before the state, the Texas Attorney General, and the courts agreed with us that his sentence was unconstitutional. And the reason why these cases went on so long is complicated, but at least in part because our office didn't exist to bring these meritorious claims to the court's attention earlier. 3 years ago, our litigation also prompted the Court of Criminal Appeals to overturn a client's conviction because of false and flawed forensic science. In that case, in short, the testimony at trial of a forensic analyst that there was nothing wrong with the forensic evidence in the case when he received it for processing. His own notes, however, indicated that, which were not turned over at the time of trial, indicated that the biological evidence was potentially contaminated and he received it in a cooler that was damp and covered in a foul-smelling liquid. Our work on that case prompted a Forensic Science Commission audit and led to the proposal and passage of Senate Bill 991 last session to create a statewide lab, crime lab disclosure portal that will allow lab notes and discovery to be transmitted to all of the parties simultaneously from crime labs. And while we're just, so I mentioned the cases that we handle. In capital cases, the When we aren't able to handle cases, there's a list of counsel that are qualified for appointment. Right now, at last check, there were 10 attorneys statewide who qualify for appointment in these cases on the list maintained by the regional administrative judges. And so these attorneys handle cases that we're unable to cover, and when we're unable to cover these cases, the counties must appoint lawyers off of that list. While we're just a few blocks away, our footprint is big. We work across Texas in counties large and small, and this gives us, I believe, a broad bird's eye view of different practices across the state, which I hope will be beneficial to this committee as session progresses. I believe also that, and I would hope that the nature of post-conviction representation, going through what was presented at trial, what could have been presented, what gives us some insight in how things occasionally go wrong. And so as this commission moves forward with its important work, we're happy to serve as a resource to you. Thank you.
Thank you. Mr. Wolf, any questions, members, of any of the panel members? Mr. Moody?
Just a couple. First of all, thank you all for being here, and I certainly appreciate all the work you do. And Chairman, I'd be remiss if I didn't thank you for your work on the Timothy Cole Exoneration Commission. You chaired that effort back in 2015, 2016, and you brought House Bill 34 in 2017, which brought a lot of significant changes to our criminal justice system to really shine a light on where problems had occurred in doing that review, and that was very difficult work. I just want to say thank you for doing that, because I think a lot of people have been well served by that work. I wanted to, Mr. Reno, could I ask just a couple of questions? You mentioned your office could be designated as a prosecutor pro tem in cases if invited in by the prosecuting attorney locally. How does that process work?
So there's two different processes.
Yeah, and that's what I was going to drill down into. There's two different ways you do this. So if you can lay that out.
And if you could identify yourself.
Yes, Josh Reno,
I know that's
Attorney General's
very
office.
difficult.
There are two different pathways. So if my folks are in a county prosecuting a case, it is one by an invitation of the elected either district or county attorney. They retain authority of that case, and we work underneath their authority. The second way, and pathway number two, is that under the statutory framework, we are appointed by, a district or county attorney will recuse, and at that point in time, there has to be someone to handle that matter, and we would be appointed by the judge that's handling that particular case, and we, as the attorney pro tem, would have the authority of a district or county attorney for that particular criminal matter.
And so when the county or district attorney recuses themselves, and I guess they could do that for various reasons, there's a conflict in the office. Is that the most common reason there's a conflict? Obviously, people come from the private bar into the prosecuting world, and that can create a conflict. Is that the typical?
There are many different reasons.
Sure.
The main ones that I see that get referred to us is you have a newly elected district or county attorney that comes in. They have been in private practice. They've got a background in criminal law, or they live in a small rural area where they've represented several people, and so they would have a conflict of interest and feel it best to recuse themselves. Now, the other thing that I would point out is, it's my understanding of the case law is that the only person who can recuse a district attorney is the district or county attorney. They have to make that decision themselves. There's not a mechanism by which someone could come in and force them to recuse.
Okay, got it. In the event, I guess that's my question procedurally, and conflicts like that are probably pretty common. Like you said, you have people coming from the private bar or in a small jurisdiction. Certainly would be a conflict to be prosecuting your former client or things that, maybe you've had interactions in a certain criminal episode that was prosecuted, and you've got information from the defense side, and maybe it would be improper. So perfectly permissible, perfectly acceptable to bring in a pro tem in those cases. In fact, I think it's the best choice. if a case progresses and that conflict is, if that conflict disappears, right? So that attorney, that prosecutor who made that decision, they're no longer in the office. Let's say they were defeated, they retired, whatever. That conflict doesn't exist anymore. Do you all continue on under the prior designation of the judge?
And you're
Or is
speaking-
there like a reevaluation of, so in that fact scenario where DA gets newly elected, they have a conflict, we're bringing in an attorney pro tem, the judge, let's say a district judge in this case, appoints the attorney general's office as the prosecutor pro tem, you all move forward with the case, you are the prosecutor on the case, and there's a wall between y'all and the office.
That is correct. And again, I'm speaking to the pathway that is attorney pro tem.
Yes.
The case law is not clear on whether or not, the most likely scenario is that District Attorney A had a conflict and recused off the case. They are defeated in an election, and District Attorney B comes into office. They no longer have the same reason for recusal, presumably, that District Attorney A did. The case law is not clear. There's a case out of, I believe, Pecos or El Paso area. There's some footnote that speaks to this particular issue, but it has not been litigated all the way through. The times that this has arisen, we've been able to either work this through with the newly elected District Attorney B in the example I've given, or we've been able to just resolve it kind of amongst ourselves. It has not been litigated at the courts.
Okay, because what could one of the options, and I know these are all hypothetical, so we don't have to dive into it if you don't, or we can talk offline, but conflict disappears because that DA is no longer there. They don't have obviously, your office has been involved in the prosecution, so it would be maybe disruptive to the prosecution to, even if the conflict is gone, to step in at that point. Could they convert, and this is the wrong way, maybe convert isn't the right word, but could they then say, we still want you in the case, we want to invite you now with our office to continue prosecuting this case with us? Could they convert it from one to the other?
It's kind of a confusing scenario. Let me state this, and then we'll perhaps unpack a few other
Because you have the
pieces.
judge in there too, who's made the appointment. So I assume they would want to say so as well.
It is my belief that once a district attorney has recused, the power of that district attorney has been granted to one of my assistant attorney generals to be, for that particular matter, and it's as specific as a cause number, that we have the power that was granted to the district attorney has now been transferred to that AAG by the court. It is my opinion that until the court takes that power away, we are, for that particular matter, making the decisions. There is a wall. It is separate. We do not converse with the office. We may have to use a copier or something like that, but we're not talking about decisions about that case with the folks who have recused.
And so in that, so the way you've explained it then, it would be incumbent upon that prosecutor to petition the court, in my example, the district judge, to say, hey, we don't have a conflict anymore. We would like for the court to, I guess, vacate whatever order that was appointing and bring the case back. I guess that's functionally how, and then what you were saying is that's not an issue that's ever been litigated because usually you just all work it out.
That's correct.
Okay. All right. Then I'm sorry to drill down on, just functionally I'm trying to understand a couple of things, and I appreciate your time on the questions. Okay.
Yeah, thank you.
Any other questions, members? Okay. If not, we certainly appreciate you all being here, and as with the other panel, look forward to working with you on these issues this session. Thank you all.
Thank you.
Thank you all very much.
Members, our final panel of two members is primarily directed to the juvenile justice system, and as all of you are aware, we have a subcommittee headed by Chairman Cook, and they're going to hold a hearing. It's posted for 30 minutes after the adjournment of this hearing, and so if anybody is interested, can stay around for that. But these juvenile justice issues do affect our entire committee, and when the subcommittee reports back to the full committee, we all need to kind of know what's going on and have a background on these things. So we've asked some of the juvenile justice participants to be here. We have, I suppose, first of all would be Ms. Chandra Carter, who is the Director of the Texas Juvenile Justice Department. Thank you for being here.
Good
And if you could
morning.
identify yourself for the
Yes.
record.
Yes, Chandra Carter, Executive Director for Texas Juvenile Justice Department. I know you all have some handouts out there, and I won't go through all of them. I will give you a general overview, acknowledging some of you have familiarity with us and have worked with us
Just
last
for
session.
I didn't mean to interrupt.
The
but
blue
handouts
folder?
are in the blue folder.
Correct,
Yeah.
yes. And the two slides that I think I'll mostly focus on are slides 4 and 5, and that really just gives an overview, an agency overview. Texas has a unique juvenile justice continuum. We partner, state operations partners quite well with our local juvenile probation departments. So we have 254 counties, and within that, we have 164 juvenile probation departments. I don't have directive authority over them, but I do have monitoring and inspection, certification of their officers, and pass-through of funds. They do incredible work. So there were 50,000 referrals last fiscal year, and they managed 99% of them. When you hear efforts like Closer to Home and regionalization, that is the hard work of our county partners. Of those juvenile probation departments, 100 are small, and 50 are medium, and 10 are large. And this is based on juvenile age population. And this is really important because the differences in the needs between large and small are very wild. For example, over half of my budget will go to counties. For our large counties, that counts for about 25% of their budget. For our small counties, that can be over 50% of their budget. Within those counties, we have 44 departments that have detention centers, and 29 of them serve youth post-adjudication. And when we think about key staffing issues, it is both for counties and for state. That is one of the key issues facing all of us. And so we all have physical beds available, but we do not have the staff available to fill those beds. I will say we are all very grateful for the investment in House Bill 1 with the increase in salaries for probation staff and for juvenile correctional officers in the secure facilities. So the largest chunk of my exceptional items are also for our county partners, and that came directly from them. I don't dictate what they need, I ask them what they need. We are really trying to work together at the charge of our chairman with a 10-year strategic plan and working these out in sort of 2-year chunks. And so we're asking for the money that the counties say that they need, but they also can spend in that 2-year period. You ask county chiefs, and there's nothing they can buy off the shelf. They have to build it. And so we want to help them build it, but we need to give them time to build it. So we see this as a both and, not an either or. We want to invest in the entire continuum. And so simultaneously, while we're trying to help counties build out resources, state operations has currently about 720 youth spread across 5 facilities. We have 50 youth in halfway houses and about 160 youth on parole. And we have about 125 youth on the wait list. So the staffing issues that I referenced earlier prevent me from just absorbing the youth on the wait list. I really work to not go over 150% capacity in my secure facilities. If I do that, that means youth will be in lockdown. I will not have enough staff to keep youth out for programming. So I really maximize the resources that I have to try and absorb that wait list and relieve the burden from the counties. But at this point, if I absorbed any more than I have today, we would be reducing programming, which we do not want to do. We also have experienced a spike in acuity of the youth that we serve, and that means that we are serving youth that have more aggression, more violence, skyrocketing mental health needs, IDD needs, and this is really complex when they come together. So both secure facilities and the counties are serving more acute youth. This has also led to a loss of contract care for secure facilities. We used to be able to have private providers that would have beds and resources and programming available for youth that have been committed to the state, but at this point, those youth, their needs are too great for those contract care providers. We also have new builds in process. So last legislative session, we were granted $200 million and tasked with creating 200 beds. And it was a very long process for us to get to a place where on Friday, our board members voted on 2 site selections, 2 locations, and those locations are now with the LBB, and once approved, we would move forward with builds. And the last item for overview is sunset. So last session, we were under sunset review, and there were a total of 48 recommendations for the state side. The ombudsman had some recommendations, but of our 48, as of tomorrow, we will only have 3 left, which is significant progress, and we're very proud of that. So that is a general overview. I'm happy to answer any questions now or in the subcommittee later.
Okay. And so our next witness is Mr. McCluskey with the Office of Independent, he's the this is a hard word to say, Ombudsman for the Texas Juvenile Justice Department. Thank you for being here.
Yes, sir. Thank you, Mr. Chair and committee members. For the record, Sean McCluskey, Chief Ombudsman, Office of the Independent Ombudsman. And I have a prepared statement that I'm probably going to ad-lib a little bit in there too. That's my kind of how I roll on that. So, the Office of Independent Ombudsman is a separate state agency that was created in 2007 for the purpose of investigating, evaluating, and security the rights of youth committed to the Texas Juvenile Justice Department, formerly known as the Texas Youth Commission. Specifically, the OIO has jurisdiction over any youth that are in state facilities, county post-adjudication, and contract facilities, as well as those youth that are being supervised out of state and on parole as well. This means that on average, the OIO is responsible for youth in over 150 different facilities across the state and other states. The office is comprised of 1 chief, myself, a deputy chief ombudsman, 3 senior ombudsmen, 7 deputy ombudsmen, and 2 administrative staff, which for a total of 14 employees of the Office of Independent Ombudsman. This year, this fiscal year, September 1st, through February 24th, 2005, the OIO has conducted a total of 186 site visits. 43 of those are in state facilities, 143 of those in county, and the office has received 709 complaints to date. 689 of those have come from the state, and 20 of those have come from the county. Now, in that 689, 565 of those are what we consider inquiries, which means we think we have jurisdiction or there's a potential for a youth rights violation, and 124 of those, 689, were referrals, which means we do not have jurisdiction, so we sent that to the entities or organizations that would, or whether that's inside or outside of the agency. Basically, 94% of the complaints have come from a state-secured facility, so that's where the bulk of our complaints come from. We have had individual cases. These are cases that we see right away that we think there's an issue or we're unable to close within a 10-day window. We've had 8 of those that have been opened. We have closed 6, and we have sustained 4 of those for some potential youth rights violation in there. In order to function more effectively, the OIO has requested in the LAR process the addition of a data analyst to better review and decipher the large amounts of data the office receives. I believe that the addition will allow our office to observe trends and patterns that potentially affect youth rights. The office has asked for 2 additional senior ombudsmen, so I can assign a senior ombudsman to each of the 5 state facilities. The addition of this personnel will allow our senior ombudsman to respond more quickly to issues and, more importantly, provide more opportunity to follow up on issues or concerns that the office has. It's just some other numbers that I think is very pertinent to the amount of territory we cover. We have interviewed over 1,921 youth to date. We have reviewed over 1,372 hours of video, and we have traveled over 47,000 miles in this fiscal year so far, visiting these different state facilities. So, to date, one of the major concerns of the OIO is the safety and security in the secured facilities. The OIO has noticed an increasing level of violence that is being perpetrated on the staff by the youth. A number of these assaults are unprovoked, and the acuity of the violence is often disturbing. The potential for violence is an issue that TJJD staff as well as OIO staff face on a weekly basis, and is something I experienced firsthand in a recent visit. Security and safety of the staff is the critical foundation in the mission of TJJD. Without this stability, it will be incredibly difficult to deliver the educational, mental health, or other essential programming to the youth committed to the department. The OIO believes that the training curriculum at TJ must be modified to address the level of potential violence, to include more scenario-based training for JCOs and appropriate staff. Not only is the staff deserving this, but the youth are also demanding this stability as well. We hear that. We hear it from the people that we serve in there, that very disruptive youth make it very difficult for them to get the programming that they, or take advantage of the program that they have, the availability in these facilities as well. So the OIO believes that the security and stability will also help in the hiring and retention of the JCO staff. This agency has concerns, our agency has concerns about the tenure and maturation of team leaders and mid-level supervisors. The success of any agency, I believe, is dependent on the skill and knowledge of these type of leaders. The mid-level managers, as I call them, the folks that are in the trenches that have the supervisory experience. They can often diffuse situations before they become critical, or they know quickly how to respond when they do become critical. In my law enforcement experience, a patrol shift or investigative division runs smoothly if there's an experienced sergeant. That's really what I can boil it down to. TJGD is no different in that regards. The OIO also has concern regarding the physical structures that are currently being utilized. Most of the 5 secured facilities are considerably old structures. They range from 23 to 60 years, and they're not built for the youth that they house today. The campuses are often too wide open and provide difficulty for staff to move the youth in an efficient and safe manner. The height of the ceilings, lack of wet cells, and line of sight issues are other areas that cause the OIO concern. All-inclusive facility structures would provide a secure environment focused on youth and staff safety, creating an environment conducive for rehabilitation, which in turn may reduce recidivism. That is the end of my prepared statement, and I thank you for your time, and any questions, please.
Thank you very much. Members, any questions of either witness? Yes, sir. Mr. Verdell.
Yep, there we go. Okay, you mentioned that staff has been assaulted by some of the juveniles in there. What's the disciplinary actions you can take against them on something like that?
Well, as far as the youth,
let me get you to identify.
yes, sir.
It's obvious because of your voices, but
yes, sir. Sean McCluskey, Chief Ombudsman. As far as the disciplinary right now on the youth, there are, Director Carter could probably speak more to that process in there. Obviously, there is a mechanism for dealing with the youth that is considerably, dangerous. I know there's some other legislation pending that's going to address some of that acuity level. So I would probably defer to her on exactly what those options are as far as disciplinary on the youth that commit these offenses. What I will say to that, 2 things on that. What I have noticed in our review is, and when I say the level of the acuity, I've seen something that, since I've been here in almost a year now, something I had really not seen when I first came in, was an example of a JCO sitting there at a table, working on paperwork, and a youth coming up and punching him in the back of the head. I've seen, a youth walk up to a JCO who's trying to move them from one area to the other, throw food at him, and then strike him in the face repeatedly. My own experience, I thought it was important to relay this, is that, I went down with some of my ombudsmen to Evans and to a redirect program, and, we are the best friend that these youth have. We are there to advocate for them no matter what the issue. I was on the dorm for a very, very quick period of time, and I had a young man who was in his cell that basically, and they knew we were the OIO. We announced we're the OIO, we're here to talk to you guys. And he basically said, if I come out of this cell, I'm going to blank you. I had another youth over there that, I walked up, tried to engage him, asked me where I was from. I said, well, I'm from West Texas and South Texas and all over. And then he said, well, I hate blank like you, and then, proceeded to kind of berate me, about why I was there. Same visit, I had another youth in a general population end up trying to get behind me. And like I said, I've been a cop for a long time. I've had, lots of people talk ugly to me. Doesn't faze me. I'm have a lot of training to deal with it, but it is unsettling in some of these areas and some of the youth that are disrupted. On the same thing, I will tell you is that there's a lot of youth that are very, you know, they are easy to engage, want to talk to you, and are getting involved in the program that's being offered to them. But it makes it very difficult if you do have disruptive youth in there for the people that are trying to do what they're supposed to do while they're in the facilities.
Yep. Ma'am, do you have on that same question?
Chandra Carter, Executive Director for TJJD. So we do have an internal due process system. Staff are available in the moment to redirect behavior through what we call egregious behavior protocol. We also have a due process system with level hearings that would allow us to move them into essentially more restrictive programming. I have what I call the violence intervention continuum. The easiest analogy would be a max in an adult system, and so these are my most aggressive and violent youth. The ratios are to keep people safe. So in my most restrictive programming, I'll have a total of 4 youth with 2 staff at all times, and they are still getting assaulted. The sentence structure also plays a role into this, and so we have indeterminate sentenced offenders, and then we have determinate sentence offenders, and those determinate sentenced offenders are rising as far as numbers in our population, and they have a different pathway in that when there are staff assaults, the Office of the Inspector General, and our chief is here if you'd like to ask him questions, will investigate, and if warranted, they will move that case on to the Special Prosecution Unit, and that unit then will decide which pathway to take. Our DSOs also have the chance of me requesting for them to return to the judge for a possible early transfer hearing.
Okay.
The judge can decide whether or not they do that. And frankly, I think people assume that the DSOs are going to be my most problematic, but they are not.
Copy that. What's the likelihood of them returning after they get done with juvenile detention? Do most of them stay out of juvenile detention once they're released? Or?
The recidivism rate specifically,
Yes, ma'am.
we just published our treatment effectiveness report, and we can certainly give you that data and really go into that in detail with you.
Okay. Thank y'all. Appreciate y'all.
Mr. Money?
I'm looking at the handout that you gave, page 11.
Yes.
Talks about the amount of time that you spend in normal programming. Can you explain a little bit about what normal programming looks like?
Yes, sir. Chandra Carter, Executive Director. So last session, we were in the worst, before last session, it was the worst staffing crisis in agency history. We were in the newspaper for being unable to provide bathroom breaks, and that was legitimate. I only have one facility that has wet cells, meaning I only have one facility that has toilets. And I did not have enough staff to ensure adequate restroom breaks. And when I'm talking about going over capacity at that time, I was at 200% capacity. So youth are locked in their rooms, and I cannot let them out for the safety of the staff. And so those dark red marks are really where we were in those lockdowns. The restricted schedule typically for us now looks like when we have call-ins. If I have a swath of call-ins, then I'm going to limit scheduling and reduce the amount of hours that they are out programming. We aim for a 14-hour schedule, and that dark blue means we're hitting the 14-hour schedule.
Can you explain what happens? I understand staffing issues. If you're properly staffed, what is that 14-hour? I guess that's wake time, pretty much.
Yes, correct.
What does that look like for someone in your program?
Yes, and we can get you a copy of the 14-hour schedule. So the youth in TJJD, we have our own high school. They go to school year-round, and so half will go in the morning and half will go into the afternoon. They have recreation. They have specialized programming depending on their treatment needs that have been identified, and they all engage in dialectical behavior therapy, and will have groups occurring in the dorms with the staff. We've moved what I call from an outpatient to an inpatient approach where treatment is day one.
How much recreation time is that out of 14 hours?
I am uncertain of the exact hours. I can get that for
Okay.
you. We have a minimum, but we try and engage in a significant amount of recreation.
And
yes.
I have not spent a lot of time around juvenile delinquents, but I've spent a lot of time around youth. I have 5 kids, and I just know that when kids are not getting enough activity, physical exertion activity, or when they are not, provided, quality nutrition, they tend to act out, and that's probably at least as or more true of people who are in a restrictive environment, away from family, and all those kinds of things. And so, I just want to know more about what are we doing to allow them. Obviously, you can't let violent people around, whether it's staff or other kids that can get hurt. But the kids who are there who are in trouble need to work, need to run, need to play, need to be tired at the end of the night, need to have plenty of protein, and so I would like to talk to you more about. And I'm not saying you're not doing all those things. I'm new here, so there's no complaint. I just would like to know more about that, because I think if we can regulate them nutritionally, physically, physiologically, maybe that will help with some of the behaviors as well.
Yes, sir, we're in agreement.
Okay.
Yes.
Mr. Latterback?
Mr. Chair, Ms. Carter, Mr. McCluskey, I appreciate the job y'all do, but the assaultive behavior that you described to the committee, is some of that environmental, and how much of this you stated, Ms. Carter, that you're skyrocketing mental health. So talk to me a little bit about that, and for Mr. McCluskey, if you're, can we do something environmentally for kids? If you're walking up behind someone, hitting them in the back of the head, there may be a fix for that. There's several options you've got there if that's becoming a common occurrence. But I'm very interested in the mental health aspect of that.
Yes, sir. Chandra Carter, Executive Director, TJJD. On slide 14, there are some graphs there that really show the spike in acuity. And so what we are looking at is a tremendous increase in moderate mental health needs, and then a pretty significant in high. The combination of that they also need violent offender treatment, is really where it gets incredibly complex. And so, yes, sir.
Excuse me, who is your service provider for mental health?
We have UTMB, who provides our medical and our psychiatric, and then we have our own internal treatment team that are psychologists, LPCs,
On
social
site?
workers. Yes, sir, all on site. Telehealth would not work for us.
Okay, thank you.
Regarding your question about the youth coming behind, I do think there are basic core correctional practices that the agency needs to really do better at ingraining, and one of the things that you're talking about is situational awareness, and that's absolutely on the radar for increased training for us.
Well, just positioning a desk would be,
That's exactly
would be
right.
a simple fix that we need to think about, especially if you're in assaultive behavior. Thank you. Thank you both.
Yes, sir.
Ms. Jones has a question.
What I'll probably do, are you two witnesses in the next committee meeting?
Yes, ma'am.
You know what? I'll save it till that committee meeting.
Mr. Wu? Mr. Wu?
Thank you, Chairman. Let's stay on slide 14. And I know I've heard you make this point multiple times about the spike in need, but I think it's important for us to look at this graph in the totality. And I kind of have some complaints about this slide and the way that the data is presented. I think maybe we flip back to page 13. Starting on the left graph, on 2020, that was the beginning of COVID, right?
Yes, sir.
Okay. And during the COVID time, so from 20 to, let's say, 23, TJJD had massive staffing issues, correct?
Correct.
And so when you say capacity, when you mentioned the term capacity many times now, what you're talking about is actually your capacity is based on the number of staff that you have and the number of kids that they can do programming for, correct? And we're not talking about a physical size limitation.
Correct.
Okay. So, and I get it was hard to staff during COVID, got it. Nobody's blaming y'all for that. But I think in terms of this graph, starting in 2020, the counties, we've told the counties, and the counties saw that the backlog, counties across the state started reassessing and reevaluating who they were sending to TJD because of the backlog, because of the severity. And many, many counties, including Harris County, including Dallas County, including everywhere else, started to stop sending kids who did not really need to be in TJD. So the number of UUMVs like joyriding and like petty theft and all this other nonsense, like lower level felonies, a lot of them like stopped coming in. Kids with higher level charges, but were very cooperative and very amenable towards rehabilitation, were also not sent. So therefore, the kids that ended up being sent to TJD tended to be very high criminality levels, like multiple repeat offenders, charged with capital murders, whatever it is. Kids with extremely high level behavioral health and mental health issues, correct?
Yes, sir.
Okay. So on page 13, and I understand in this respect, when you're talking about the totality, the percentage of who makes up the population, there would be a spike.
Yes, sir. There's
Okay.
a spike in the percentage as well as the overall number.
But the overall number between 2020 and 2023, the number of kids in TJD went down significantly.
Yes, we had a drop in population artificially due to the wait list and COVID, and it feels like we are back to those pre-pandemic levels.
So when we look at this graph, and a lot of the counties are keeping their policies of not sending kids who don't need to be there,
Yes,
just
sir.
because they could, and not sending kids who are already being treated and treated well inside the counties. I don't think that's changing. I think they're still basically, they're sending slightly more. The backlog is coming, is being undone. We went from about, what, mid-fives, 550 or so, to now we're in like low sevens.
So I think slide 12 helps articulate what you're looking at because it gives the actual numbers.
Yeah.
Yes, sir.
Right? So, but I want to be clear that when we're talking about this like giant spike in capital murders, it's not a giant spike in capital murders. On your slide, on slide 16, the number went from 2 to 11. I mean, that's I guess 500% increase, but it's from 2 to 11.
Yes,
right?
sir. And the referrals for homicide from 2020 went from 66 to 156 in 2023.
So, and like on page 16, again, going from the bottom to the top, 2013, 18, and then 24, we're going from 800 kids in care to 748 to 578.
Yes, we are 200 youth higher than we were last session, but when we look at our population, I also want us to make sure we're including that 125 on the wait list.
Okay. I mean, like literally, TJD population is half of what it is when I first got sworn. Okay. So I understand that a lot of the difficulties that have happened come from that the population that is in care is now a different mixture of kids.
It is a very condensed, yes,
Okay.
correct.
But at the same time, the number of kids have gone down, and there is, and every single session we come back, we increase the amount of resources that TJD gets, correct?
Last session was my first session as executive director, and you made a significant investment.
Okay. And I'm sure it's before your time, and you were like probably a little lower level before that.
Yes, sir.
But we made additions to TJD continuously. And every time we come back, and I sent on approach over this as well, every time we come back, we say like, hey, tell us what you need. Like, there's all these problems, let's fix them. And we say like, hey, tell us exactly what you need to fix this problem. We give the money, and we come back the next time, and the problem is still there, and it's actually gotten bigger. I appreciate you being here and talking to us about this. I appreciate your work on a lot of this stuff, and I know there have been some significant improvements that have been made. But like in your testimony here, in your testimony in appropriations, I think you have left out the single biggest 900-pound gorilla in the room, and that is the DOJ report. And in every time you've testified in front of a committee, you have not mentioned the DOJ report, right? Which is, I think, a scathing rebuke of the state in what we've done to address the population of probably one of the greatest, most difficult populations to have, also one of the most underrepresented, undertaken care of, and a population that simply will get worse if we don't help them. And my frustration with all this is, you know what, let me switch. Sorry. Mr. McCluskey, I'm sorry, I have to try to remember your name. Part of the DOJ's report was about the Ombudsman's office with lots of details about exactly what was wrong during the report. Many things like the fact that many youth complaints simply did not make it to you at all in any way, including procedures that required other staff to have staff members actually pick up and send over the complaints, meaning that staff who were being complained about got to pick up the complaints and send them over and read them. Or asking kids, asking other youth to be in charge of that. Tell me in front of this committee what you have done to make sure that these things do not happen again.
Sean McCluskey, Chief Ombudsman. So as you can tell, we do receive a large number of complaints that come in. They come in, we receive them, we put them into a database. We are on these facilities all the time. We are continuing to interview folks, interview kids. We receive letters that come in of complaints, and we look at, if you remember, we've reviewed 1,300 hours of video. We sit there and watch video, and we oftentimes see things that nobody has brought to our attention, that's oftentimes not brought by a staff member or a youth, and that's where, and we see things, or we look at a report, and we say, that report doesn't jive. Something is not off there. And then we start looking into that. So we are doing what I think is the absolute bandwidth of the people that I have, and which is why I'm asking for more folks. And quite frankly, I need more than, now that I've been in this job. Well, the first time I came in front of the original committee, I'd been on the job 4 months. I do have a different perspective of where I'm at now. You know, a sweet spot with me would be, I've asked for 2 more ombudsmen. I really need probably 2 more than that to just focus solely on education and focus solely on training. So I would say right now we are doing whatever we can. I've requested our ombudsman to be in the facilities more when they're doing the state visits, to add a day on that so we could go see things at a different time period. You know, we have a lot of facilities that we cover, and so the data analyst to me is absolutely critical. We have so much data that I'm looking at, and I can't really tell, you know, what it says. Other than I have some spikes here, I have some drops here, I look over there, but I don't have anybody that can really do that. And I want it to have all my own numbers because I am an independent agency. I want to be able to confirm what TJJD has, or I want to be able to push back on what TJJD has. You know, I'm basically, you know, when it comes to data, I'm like a gremlin that got entered into to the Daytona 500. I mean, I paint it purple, but I'm still going to be a gremlin. I just cannot keep up with it, and so forth. So that's why we are trying to get as much, you know, structural support for us to be able to do the things that I believe we need to do.
I understand the post-report processing, right? But that's after a report has come in. A lot of and that was part of the DOJ's report, but I'm more concerned about if a child says, I am being sexually abused and no one is helping me, and they send it to you, how do you ensure that you will get that?
All I can say is we have the processes in place that we have right now. We have we are constantly.
But the process in place previously was the problem.
I would have to say I'd have to go back and look at the statistics on that. I couldn't tell you that, other than I know we receive a large amount of complaints. Again, and if it's a criminal issue, that's not something that the OIO would handle. We would pass that on along to the OIG on that. And so.
And Mr. Let me kind of re-ask what you asked, because I think you made a good point, and that is, let's assume I'm a resident in one of the facilities, and I have a complaint. How do I get it to you?
There's a phone that is always available. There are posters on the wall, how you contact the OIO. We are on these facilities every month. We're there walking around, we're the OIO. We have shirts on that say, we're the OIO. So we have the call center that comes in, that's manned, that's 24 hours. It is much right now that I know to do with the staffing that I have to be able to receive these calls.
So they can go directly to your office? They don't have to go through some other staff member to
They
get
can
to your
walk
office?
up, pick up the phone, and they could call us.
I'm sorry.
And I think the problem, in the report, I think mentioned that the problem partially was that these kids didn't have access to the phone. Like, the phone was there, and sometimes the phone worked, sometimes the phone didn't work, but a lot of times the bigger problem was these kids were simply not allowed to have access to the phone. And then if they had access to the phone, a lot of times there's a staff member that's standing right there next to the phone. And I think this is a part of the internal process that is a problem that needs to be addressed to figure out if a child wants to make a report and they don't feel safe, they've already gone to their staff member on their floor, to whoever else they can go to, they don't feel like they can go to anyone else. They say, I'm in trouble, I need help, I'm being abused by another kid, I'm being abused by staff, or whatever it is. How do we make sure that we can actually address these incidents of abuse? And that is the crux of the DOJ report is abuse is happening in the system. The same abuse that's happened when it was a TJD, and even after we made it not TJD, the same violation, the same kind of abuse was happening. We thought we fixed it, we put more money into it, changed the laws. We come back 5 years later, we get this DOJ report. It's the same violations again and again and again. And I don't know what we're going to do about it. And I keep, in the report, the DOJ report kept saying, hey, the processes that they have in place are not sufficient. They do not address the needs. They do not address the problems. And we keep asking in the probes and everywhere else, what are the changes that are going to be made? And people keep saying, well, we're going to follow the rules. Well, the rules were in place last time. The rules were in place when these reports were made. And that's not, I don't think having rules is a problem. I think people not following the rules or the rules are not complete is an issue. And every time I ask, the answer is always the same, well, we're working on it.
Well,
Can I respond, sir?
Please.
Yeah, so Chandra Carter, Executive Director, certainly I want to validate the frustration that you're expressing based on the report. I do disagree that we are not the same agency as we were in 2007. We are in negotiations with DOJ, and we are working with the Office of the Attorney General and have been given guidelines on what we can and cannot share publicly as we're in these negotiations. We're happy to meet with any of your offices to discuss this, and I am confident that my deputy behind me, Sean Grove, who is point when meeting with DOJ, is chomping at the bit to respond. So we can certainly do that with what we're allowed to discuss now or in subcommittee and also in your offices.
Mr. Chair,
Yes, Mr.
I would love to hear the DOJ report. I would love to hear what Chairman Woob is complaining about here, that nothing has absolutely been done in years. So I don't believe that right now, and I need to hear from someone else.
Yes, sir, we're happy to.
Thank you very much.
And members, especially the new members on the committee, if you need a copy of the DOJ report to look at, I'm sure we can make one of those available to you. Obviously, there's two sides, so when you read the report, I'd urge you to talk to Ms. Carter and the folks as well, just to kind of, because that's a snapshot from several years ago. What was it, 2009?
October 21.
Yes, sir.
October 21.
It was the same time we were under sunset review and in the worst staffing crisis.
And so things have changed. Some things have changed.
Yes, sir.
Since then. So, but I would urge you to look at that and ask any questions you might have. Ms. Jones?
I was going to say my comments to the Juvenile Justice Committee, but since it's okay. And let me say this. I'm a 30-year lawyer. Been doing on the criminal side for the majority of my career. I get calls all the time as a lawyer, complaints about how both grown-ups and kids are treated when they're incarcerated. Let me be clear. I also used to be a kid. Kids believe in fundamental fairness. If I'm overpunished, some kids are like, you know what, if I'm gonna get in trouble, I'm gonna get in good trouble. Especially if they come to you and ask you for help and you don't help them, because grown-ups are supposed to protect kids. My concern about how you've presented has only been how you've been assaulted, and it's not telling the whole story. Furthermore, it's been a minute since I've been in math in school, but I understand when the denominator gets smaller, the number on top gets bigger. So it's not entirely accurate how you've presented the murders, right? And so my concern with what I've heard from the presenters, the invited presenters, is just like one side. There's definitely a difference with perspectives, people that are law enforcement and other people like social workers or whomever. And what I'll say is this, is if we screw up with kids, they're going to be more screwed up adults, right? And I'm gonna say it again, because maybe people aren't listening. When we screw up with kids, they're gonna be more screwed up adults. And for me, it's unacceptable that you say we basically trying to put out the fire with the fire hoses going in our face, right? We have a staffing crisis, but you are keeping track of what's happening to the grown-ups in these facilities, but you're not keeping up with the kids. And even though, this is the first time I've been, even though I didn't ask to be on crim jur last session, I don't know, because I don't want people to think that's all I know how to do when I have an extensive law practice. I did ask this year because I paid attention to some of the stuff that came out. Some of my colleagues who are on this committee would come ask me because I actually practice criminal defense work. But so to those who haven't seen the report, it came out August 1st of 2024. Talks about a bunch of stuff: failure to protect children from harm, excessive use of force, prolonged isolation, sexual abuse, ineffective guidance system, inadequate mental health care, deficient special education and disability services, disability discrimination, and there's a bunch of recommendations for remedial measures, which I don't feel like getting into right now because I'm certain we'll have time to do this. But if, in fact, money has been thrown at the problem and we are where we are, that's unacceptable because you're the grown-ups, right? And if somebody knocks me in my head a lot and the grown-ups won't protect me, eventually I'm going to knock them out. Let's be clear. That's human behavior. If adults don't protect kids, kids are going to act out. Apart from, as my colleague said, and he hit the nail on the head, even like nutrition, where people's teeth are rotten when they go to prison because they don't have good dental care. And they come out with all these problems like simple stuff. And if we treat kids like animals when they're kids, they're going to be animals when they're adults. They just are. And so what I'd like to see is, because I'm real irritated right now. What I'd like to see is a more diverse presentation of speakers so we can hear all sides. Because, there are some kids, like, I have two cousins. One is just got out of prison. The other one, I have a whole bunch of cousins who were in prison, but that's not the point. They started out when they were juveniles. But one of them was murdered, actually, when I was on city council, and his brother just got out of prison. And it's interesting because as a family, we didn't know how they lived their lives. I mean, people are struggling every day trying to figure out how to pay bills, feed the kids, get them in school. And what I did not know is their trifling mother, talking about she married into my family. Their trifling mother took both of them out of school when they were 8 years old and had them selling, right? Drugs. We had no idea. So I think about my cousins and I think about how successful you're going to be if your mama took you out of school when you're 8 years old and you like slanging. That means selling drugs, right? So then you wonder why my cousins end up having a violent records. They start getting in trouble when they're younger. Well, when you are a baby drug dealer, because your mama got you selling, the grown-ups are trying to take your product. Because when you get product, you got to pay the people that give you the product. And so you got to protect your product, which means you might have to beat somebody up, shoot somebody, stab somebody. Now, mind you, we have no idea as a family that this is going on, because who would think a mother would take her kid out of school when they're 8 years old? So there are a lot of kids who just don't know better because they weren't raised better. And so I think the criminal justice system, some would call it the criminal injustice system, needs to be able to address these things when you have like social workers. The kids may sometimes tell you stuff that you just don't know. So for example, my other cousin, the one that just got out of prison, when he got out of prison, again, he was used to being jumped by bigger boys trying to take his product. So he has a whole different perspective. Now when he got older, I mean, I didn't realize he was taken out of school when he was 8 years old. So it's not like you can get a good job when you got a 8-year-old, what's that, second grade, maybe, third grade? You ain't gonna get no good jobs. So I think there's a bunch of issues going on. And so when my cousin who got murdered, when I was on city council, when he was dead, I saw a person laying in the parking lot of some apartments in Houston dead. And people saw my cousin as a drug dealer. And I saw a kid who was failed by everybody, including his trifling mama, who I can't stand to this day. Right? So you're telling stories, and it's not always accurate, but if we don't protect these kids, we're going to see them in the criminal justice system. And then I would be curious to know, how much does it cost the state to house people when we could literally be dealing with some social issues? And I get that you're frustrated. Your people are probably frustrated. They're overworked and underpaid. But you judge a society by how you treat the young people and the old people. And if we can't protect our kids and our old people, then what a society we have. So I don't want to. I just think that if you responded to my colleague, if you can't do it because of something with the DOJ and they want whatever, I'm hopeful you can speak to me about it offline. Because this DOJ report, I don't care if they did stuff in 2021, right? Because I literally get calls today about treatment inside. And desperate people do desperate things. So maybe they need to steal you. For those of you who don't know what stealing means, it means coming up and hitting you from behind when you ain't looking. That's a colloquialism, ebonics. So I wasn't going to talk about this until juvenile justice, but this is not simple. I don't believe in just throwing money at problems. I want to know what you're doing to help the kids, and I want to know what you're doing to fix yourselves. Because I don't think you can have one without the other. And I'll leave it at that. I'm very thankful that the speaker made me vice chair of juvenile justice, because I definitely think I have a perspective. I definitely think I have a perspective that may not be up here. But I need for you to guys to give a more accurate presentation about all sides, which includes telling your flaws. Thank you.
Can I provide one comment,
Yes.
Chairman? I agree with you. I worked 10 years in adult corrections as a therapist. I happen to be a licensed clinical social worker. And I choose juveniles because I believe in rehabilitation. That is absolutely the heart and soul of why I'm here. And I do believe we are in an excellent place as compared to where we were. But I'm also very clear about the work ahead of us. And I'm confident in myself and my team that we are going to be able to do this. And I'm happy to explore what all of this looks like with you.
Thank you, Ms. Carter.
Thank you. I would like to hear about this DOJ report, which 15 minutes ago we were talking about.
Yes, sir. We have a resource witness, Deputy Executive Director Sean Grove, who is point on the DOJ, meeting with DOJ, and can talk about what we're allowed to talk about. Can we invite him up to speak briefly?
Would you like to hear?
I sure would.
Okay.
Yes,
All
sir.
right, come on up. And if you would, identify yourself.
Yes, good afternoon, Chairman, members. Sean Grove, Deputy Executive Director for the Texas Juvenile Justice Department. And so on the DOJ report, there was a complaint filed to the DOJ in October of 2020 alleging certain conditions within our secure facilities. The DOJ began their investigation in October of 2021. They began site visits in May of '22, which is, if you look at the handouts that we presented, does coincide with when we were in those 22-hour lockdowns in terms of not having the available staffing to ensure safety and security in our programming in our secure facilities. I believe that goes to a question from Representative Wu in terms of access. It is very likely that the DOJ, when they were at our facilities and we did not have enough staff and youth were in lockdown, that at that moment there was concerns about access to the Blue Phone system and to the youth grievance system, both of which have been improved on with our robust increase in staffing brought by the resources from the legislature last session. During this time, during the DOJ investigation, we reached out to them several times, certainly during last session, to identify if there's any concerns that the DOJ may have about the conditions in our secure facilities or about the program that we offer to juveniles in our secure facilities, that now is the time to provide that information. August 1st of 2024 is when we received that report. We received it at the same time the rest of the world. And in that report, the DOJ does allege that there are constitutional violations in our secure facilities and a range of issues that I believe Representative Wu spoke to a little bit earlier. And we are clear for those members that were in JJFI last session and the members that were in the sunset hearings last session, we were sharing the very same concerns that were addressed in the DOJ report in terms of our ability to provide the safety and security and the programming to the youth in our secure facilities based off of our staffing. And we are confident that if we have some additional help and structure, which Chair Cook has a bill that is currently filed in terms of the youth accountability pieces that I believe you had asked about earlier with both Chief McCluskey and Director Carter, as well as additional staffing that is in both HB1 and SB1 and our ability to get more robust staffing in our secure facilities, that we will be able to continue to move forward with addressing those concerns. And so we provide that information last session to JJFI, to Sunset, continue, as you said, Rep. Jones, to talk about those issues that are confronting our system, our secure facilities, so that we can have those robust, frank conversations about what's needed in the juvenile justice system. And none of those rise to the level of a constitutional violation. And so when we are discussing with the DOJ about certain concerns that rose into the DOJ report about what our conditions in our secure facilities look like currently with 200 more available staff than we had 2 years ago. Yes, there are conditions in our facilities that we are actively working and have some of the best and brightest staff as state public servants in our agency right now, working to improve those conditions and in programming, and none of them rise to the level of a constitutional violation. And that really is the crux of the disagreement with the findings from the DOJ report.
Yes, Ms. Jones.
Are you a lawyer?
Yes, ma'am.
You know what due process is?
Yes, ma'am.
So if I make a complaint that somebody raped me, and I literally don't have a hearing, that is a violation of the Constitution because I'm entitled to due process. So I think that if people are giving you constructive criticism, you maybe should listen and not be defensive, because I don't know how many. Again, this is my first meeting for crim juror, but if I'm making complaints about, raping me is a violation of my Constitution, especially when it's a governmental facility and I'm not being heard, that rises to the level of a constitutional violation. So if the person that is responsible for responding to this with the DOJ literally doesn't get, and he's a lawyer, that's a constitutional violation, I'm just wondering. And do you have kids?
Yes, ma'am.
Some grown up raped, you got a daughter?
Yes, ma'am.
If somebody raped your daughter and nobody listened to her, would you be angry?
So, Rep. Jones, I would love to explore this more with you in terms of the allegations in the DOJ report. I'm not aware, I don't believe that the Office of Independent Ombudsman or the Office of Inspector General or the Special Prosecution Unit, we are not aware of an allegation of sexual abuse within our facility that was not handled directly in terms of the Prison Rape Elimination Act standards that we are in full compliance with, that was not handled appropriately in that moment, that was not investigated to the fullest extent, and in instances that are appropriate, prosecuted by the Special Prosecution Unit. We're not aware of an instance like that, Rep. Jones.
Like I say, I get calls about stuff. They ain't got nothing to do with the DOJ report. And I'm appalled, and I try to, address those issues from my state rep office. If it's not a case that I take or what have you, I try to balance, right? Because I don't want to mix them. But my point is that one of the reasons that I decided to practice criminal defense law is because my uncles, all of them told me they got locked up for crimes they didn't commit, and they had to sell out court-appointed lawyers, which is one reason why I do court-appointed work, because I don't think the quality of your legal representation to depend on how much money you make, right? So it's interesting because it's almost like we're in a tale of two worlds. And I think it depends on who you talk to about whether you think the criminal justice system protects and serves or oppresses. So I think we just need to have more open and honest conversations. And I think that if someone is giving you criticism, I mean, the best assessors of what's going on in the place are the people that are there, right? And there's nothing quite like telling somebody something's happening to you and people are not listening. They don't, So, but back to my point, if somebody raped your child, and people didn't listen, you'd be upset, right? And I'm certain your child would be upset and probably damaged. So I just think we need to, if you don't think that what they're saying, it's sort of like being an addict. If you don't accept that you're an addict, you are not gonna get better. And so the only way, I think, for the juvenile justice system, especially the governmental agency that houses the kids, if they don't accept that they have problems, you can't fix it. And if you mistreat people long enough, they're going to defend themselves. And that's all I have to say, but I'd love for you to come to my office and we can have some really good conversations.
Absolutely. We welcome that, and for the panel and for the members. Anytime you want to go to any of our facilities and see the good work that our staff are doing and see what it is like within our secure facilities, y'all reach out anytime. We're happy to facilitate that visit. And I would also share, because you had mentioned this just a little bit, Rep. Jones, and we hear this from some of the advocate community as well. If there are allegations that are not made to the Office of Inspector General, that those must be called in so that we can ensure that there was proper investigation, that we are protecting the rights of the victim, that we are pursuing all of the to the ends of the investigation that we need to be able to pursue. And so if there are allegations out there that we're not aware of, they must be called in so that we can make sure that there's an investigation.
Mr. Moody has a question.
First of all, I appreciate the conversation. It's certainly a very complicated one. Would encourage this report is public, something you can review. I want to be clear that you're in a current conversation with DOJ, certain things not proper to disclose publicly. Is that correct?
Yes, sir.
Okay. However, and I just want to be clear, I know there's a lot of freshman members on the panel, and there are opportunities to share those things through legislative privilege privately, right?
Yes, sir.
Now, I think members, it's incumbent upon them to essentially sign that they're going to comply with the confidentiality of those records. I've engaged in a couple of these meetings over my career. I'm sure Mr. Smithy has as well, when there's sensitive legal issues that are going on that aren't right for public conversation. You can ask that. And so if those members want to have those conversations with you, I'm hearing there's an invitation to do that.
Absolutely. And,
Okay.
and you're correct, Rep. Moody. Unfortunately, the way that the law is written, you do have to request it under legislative privilege, and then we will happy to provide you all the information that we have.
So in folks, be mindful of the work they are doing. Like these are findings that were made. They can sit in a room and talk with you about one by one. If you've ever gone through audit or anything like that, you may know, like, well, I see what you're saying here, but I disagree with the way it's, being portrayed, or things that we could have done or didn't do. What I would ask for me in my office, and I may request one of those meetings, I don't know yet, but I think what would be helpful when you do have those meetings, so just my suggestion, is in the DOJ report, it concludes with the minimum remedial measures. These are what they recommend that you do to address the issues that they identified, DOJ identified. And so usually when you're going through these conversations with DOJ, you are going one by one, piece by piece through these, and it's address, dismiss, or however, I don't know the lingo, but it's going to be something one by one. I think for anybody who really wants to dive into this, that'd be a helpful conversation to have. Read the report in full. It's 70-some pages. It's written in an accessible fashion. Like, you'll be able to read this. And then I would, if you want to, I would ask these folks to sit down with you. If you want to request that information, the legislative privilege, you should. And then from the agency side, I think going through those remedial measures and how you've worked through them, maybe some that you, and not going to put words in your mouth, maybe some you disagree with. These are not appropriate findings, and here's why they weren't appropriate. And that's fair too. I think that's the kind of conversation I would encourage all of you to have. And because you could have a more open conversation based on where you all are at in the process, you can request those through legislative privilege. So I want to thank you all, and I just wanted to help kind of steer the conversation because there's a lot to talk about here. And I'm sure Mr. Cook is going to talk about the rest of it once the rest of us leave. But to get a full picture might be the best path for members to do that. I think it would be helpful. So thank you all very much. I appreciate your time.
Thank you for those comments. Mr. Wood, did you have a question?
So, yeah, I want to follow up on what both Rep. Moody and Rep. Jones have talked about. And I want to make I said this previously, and I want to say it again, because I think we're still dancing around this. I think one of the biggest problems is that the agency treats this report like it's a nothing. Like this is no big deal, because every time, y'all never, anytime we have meetings with people who are not in the JJ world, it never gets mentioned unless one of us brings it up, right? That's number one. Number two, whenever we talk about it, whenever we ask questions about it, whenever we address issues, it's like, oh, well, it was just a one-time incident. It was no big deal. It was taken care of. We took care of it. The DOJ report consistently said this is a pervasive culture throughout the agency of not doing what they're supposed to be doing. I know body cam issues are one of the big ones in the DOJ report. And listen, this is from the report itself. In September of 2020, the Office of Inspector General concluded that a March staff member had committed abuse after body camera footage revealed that he had engaged in overt sexual conversations with a child about female genitalia, oral sex, and other sex acts. Transcripts from his body-worn camera reflected the use of violent, sexual, graphic, and obviously inappropriate language about the children in his care, including advising that the children should be on guard or they may wake up. That's one. Earlier that year, it was concluded that another staff member had abused a child by soliciting and enticing her to play with herself in her cell. Investigators again determined that this staff member had turned off his body camera over a dozen times during his shift on that day, and that he had engaged in an inappropriate conversation right before turning off his camera. And the report notes that an immense percentage of staff members turned off their cameras consistently when they were interacting with the children, which was the entire reason for ordering them to wear the cameras in the first place. The DOJ made this a big deal because the body-worn cameras is one of the ways we keep staff from interacting inappropriately because it can be reviewed. But it only works when you don't turn off the cameras. The TJJD staffers continuously, repeatedly, as a cultural touchstone at TJD, turned off their cameras when they felt like it. And I asked you in a different committee hearing, have any staff been disciplined for it? And you said yes. And I said, please, tell me how many staff have been disciplined, how many disciplinary reviews have been done, how many things has this corrected, because DOJ, the report says, this is 30%, 40% of the staff members do this on a regular basis, or something like that, right? And the response from TJD when we ask about this, again, hey, what are you gonna do about the body cams? How are you gonna fix this? How are you gonna change this culture? How are you gonna work on making sure that this doesn't happen again? Because the body cams are part of our safeguards. If you can't safeguard the safeguard, what's the point of everything else? And repeatedly, the answer that we get is, we have rules about it. Well, there were rules about it prior to the violations. There were rules that say you're not supposed to turn off your body cams. You're supposed to wear them whenever you interact with kids. right? Only unless it's like a really personal, the kid's about to undress or something like that, should you ever turn them off. And essentially the answer from the agency is the rules we had in place while the rules are being violated are our solution to the rules being violated. Is that correct?
Chandra Carter, Executive Director. First, I just want to be clear that I have never once said that these allegations or these instances are no big deal. I have never once said that.
But that's the attitude.
I understand that's how you are perceiving it, but that is not how I feel. We have made changes with our body-worn cameras. We are in process with the vendor, and certainly we can go through all those details now or in your office. Through the measures, the remedial measures as recommended by the DOJ, we are making progress, and some of them we disagree on. Some of them we've made significant progress, and the only reason we've been able to make progress was the investment from last legislature.
Is there a policy that says if you turn off your body camera during an interaction with a child, you're immediately terminated for
It's
cause?
discipline up to and including termination, but we've switched the policy. Now's appropriate time if you'd like to share.
Yeah, absolutely. For the record, Sean Grove, Deputy Executive Director. So there's no time that it's appropriate for a staff member to turn off their body camera and engage with the youth. So when staff members do that, we terminate. The issue on the specific portion about the 30 or 40%, I forget which part of the report, I think the sample size was small, and I'm not trying to dismiss that, but I do think that the information is important in terms of our use of body cameras. And so we do track the usage of body cameras. If a staff member turns their camera off and engages with the youth, and that staff member will be disciplined, and most of the time that does result in a termination. And otherwise, if a staff member has perhaps maybe an anomaly where for a 12-hour shift for a JCO, if there's 8 hours of recording footage, that staff member is also subject to additional monitoring to determine
I don't
what is
understand.
going
I
on.
don't understand two things. I don't understand most of the time because under what circumstances would it be okay and not terminable offense to turn off a body camera in an interaction with a child?
So no circumstances there, and we can get the data in terms of the discipline for the committee. We can share that data in a public hearing as well. If a staff member is approaching a youth and turns off the camera, that would be a termination every single time. If a staff member has an ability, say if they were taking a restroom break and they forgot to turn their camera on and engages with the youth, that may be looked differently. But if I'm approaching a youth and I have a juvenile correctional officer who has a body camera, and as I'm approaching that youth, I intentionally turn that off, that is a termination every time.
And are there? You may have just answered this before, but is there a routine, regular ability and intentionality to audit that so that we're sure we're dealing with that either through your office or the ombudsman or whoever?
Yes, and so we have a monitoring and inspections division internally. I can speak to the internal mechanisms, and of course the chief ombudsman can speak to what the ombudsman's office looks like. And so our staff undergo pretty intense monthly monitoring. And so when I say monthly monitoring, that's not a snapshot each month, it is throughout the month, and we receive those reports. And so for incident-based but also random monitoring of both overhead and body-worn camera occurs regularly for every shift pattern at every state secure facility. In addition to that, we also, as I had mentioned, look at the body-worn camera data. With our new cameras, which are the Axon 4 body-worn cameras, we have an ability to tap into more real-time monitoring to also determine if a camera is being turned off in the moment, but also be able to run
What about a camera
better
that just
reports.
doesn't turn off? What about a camera that just stays on, and if they need to go to the bathroom, then they go somewhere, they take it off, they go to the bathroom, they come back, they put it on, but if it's on your body, it's on.
We have updated the policy because the features in the new camera allow different footage, certainly different like recording capabilities. And so instead of turning the camera off in the instances that you had mentioned that are allowed for staff to turn their camera off, there's a sleep mode for the camera, but we've also tightened up the instances when a staff member can put that in sleep mode. So really we're talking about an investigation from the Office of Inspector General if there's an interview, approved restroom breaks, but we really are tightening up when that could even be in sleep mode currently.
Yeah, I'm talking about just take away the capability to turn it off. It just, I mean, you know, whether I'm around kids, whether it's around church, whether it's whatever, you have policies in place so that you don't even have the ability for someone to falsely accuse you of doing something that that would be harmful to the child. And so, you're never alone with the child. The camera seems to be a safeguard for the officers as much as for the children. And any scenario where the officer turns it off should be an enormous red flag.
Absolutely, and it is an enormous red flag.
Ms. Jones?
Yes, Chairman. Isn't it true that y'all take every violation, that every complaint that's brought into you very seriously about our children?
Yes, sir.
Isn't it true?
Yes, sir.
And how many body cameras are out here? How many body cameras? Many people on this committee know about body cameras. Law enforcement has them. They're throughout the industry. Now, they may not know that they don't work all the time. And they may run out of battery. They may run into technology issues. I mean, you've ever had a problem with your cell phone? I mean, things like this happen. It's unfortunate. We try to get them fixed as soon as we can. You have budgets. You have any number of reasons why we can't have a body camera. That needs to be brought out also, because, I mean, this is a fact of life, of humanity. When you've got a body camera on you every day for all your shift for 12 hours, 14 hours, whatever it may be. So we run into problems here. But I don't think for a second that we don't take every complaint very seriously with our youth. Thank you all.
Thank you.
Ms. Jones, question?
I'm so glad I'm on this committee this session. When you vice chair, who's co-chair, whatever that is, whatever his title is, when he asked about specifically staff turning off their cameras, the response was, we're talking to the vendor. What does the vendor have to do with the staff turning off their cameras? And again, I'm gonna say this till I'm purple in the face. If somebody tells us something, right, and we wanna do better, especially by our kids, we've gotta look at it. When I was a baby lawyer, there was a guy who sat on the bench in Harris County. His name was Judge Ted Poe. They say he locked his parents up, which was a lie. But the one thing I learned very early on in my law practice before Judge Poe was this: when lawyers would have their clients come up and we're trying to get him to be fair with our clients, and the defendants would make excuse, Judge, please don't do this. I'm the sole caregiver for my child. If you lock me up, my child's gonna go to CPS. And Judge Poe said, well, you should have thought about your kids before you did what you did. Why are they important now? I say that to say this. Judge Poe taught me that when I'm talking to my clients, I say, look, you made a bad decision. It wasn't a mistake. You intentionally made the decision that you made. And the question is not how you fell down on this. The question is how you get up. Are you going to learn from it? Are you not going to make that same mistake again? And the only way for that to happen is for you to, with good faith and an open heart, receive the information and not be defensive. And so you go to Judge Poe and you say, you know what, Judge, I stole that stuff, or I did this, and I will never do it again. I take that. That's what I did. And I learned from this. I'm not going to make the same mistake, and I'm going to be better for it. And then that person has a chance to rehabilitate, since rehabilitation is important. So I just think, based on whenever people are saying difficult things for you to hear, because you are far from perfect, just for me, stop being so defensive. Because if you can't accept obvious stuff, like 30 to 40% of the staff are turning their cameras off when you got a video showing he was doing inappropriate stuff immediately before he turned it off. And because I know that, I've been doing this for 30 years. I know Rep. Lauterbach has been doing it for longer than me, but I think 30 years is a pretty good long run in our age before beauty. But there are just certain things that I've learned. If you want from me to accept that you really are trying to fix the problem, and I want to help you fix the problem. If giving you some money or voting for you to have some more money helps with the problem, I'm happy to do that. But if you only make excuses when they make things obvious to you, it's problematic. And if 30 to 40% of people are turning off their videos, and 30 to 40% of the people weren't fired, I got issues with that. Because these are children. These are children.
Would you like me to answer the question about the vendor?
Absolutely, and I hope it's not defensive.
Chandra Carter, Executive Director. Part of the issue is the amount of overhead camera and body camera footage that we have. We have about 120,000 hours in a day, and trying to audit that is very difficult. When we got the body cams in 2018, there was no capacity for them to run a report to tell me who's turning them off. And so we had to manually sort of dig through and rely on the resources of other departments. So it was just not possible for us to get that data, but they are improving what we're looking at right now with them.
So would you agree with me? Like, you've got your staffing problems, you don't have the ability to look through the footage, because when I get cases where there's a lot of body cam, it takes a lot of resources from my office, right? Because it's what I don't see that'll get me in trial. Trust me. So I understand that, right? But would you agree with me, regardless of your staffing problems, if you're that kid who made the report that somebody specifically did something, that regardless of your staffing problems, that's still a problem? And if I'm a kid and I say, you know, CO, this person did this to me, it seems to me that it would make it easier for you to go focus on that CO when he's there, right, to look through that. So I understand your dilemma, but you also have to understand that inappropriately talking to a kid about sex, talking about violent sex, people are afraid of retaliation. I hear it. I get calls to my office, will you please represent my child who's locked up, right? So I get that you have some struggles, but you've got to figure it out. That's why you're at the top of the agency, because you've got to have those, right?
Yes, ma'am.
But what I need is, I don't need you only to focus on the bad behavior they're doing. I also need for you to acknowledge and fix the bad behavior you're doing.
Yes, ma'am, I am.
Okay.
Mr. Mooney.
Last thing, I am I'm not a technical whiz. I'm new to this committee, but in talking with your vendors, if you have not done already, you know, I have smoke alarms in my house, and if the battery starts going out, it beeps to where I can't deal with it anymore. If the battery malfunctions, it goes berserk. And there's no way to turn it on or off. It's either on or the battery's out of it. So I think the vendor understanding that not just JJD, but every law enforcement and corrections institution in the world would like to have the kinds of protection, once again, not just for the inmates, but for the officers as well. Once you make a decision to open transparency, that needs to be, which we have done, and rightfully so, that needs to be something that can't be turned on and off at a whim. It should be always on, and when it goes off, there should be red flashing lights in your office or whoever to make sure that happens. And so if additional appropriations are necessary to make that happen, I don't like to vote for the government to spend more money, but that's an appropriation that I would be willing to fight for. But once again, I don't think it's that expensive to just take the off button out and make it just always work.
Yes, sir. Chandra Carter, Executive Director. We do have an exceptional item that has some AI potential, and what we're looking at is the cameras collecting, and it will learn as it goes. And again, I'm not an IT whiz either, but my understanding is that it will identify things that we flag as issues and then real-time report to the facility to address, and that is something we're looking to get funded.
Including on-off malfunctions, all of that?
I'm unsure of all of that.
It's one thing for them to tell you, hey, there's a disturbance happening over here that we can see on the camera. I'm just talking about basic camera functionality.
So
for the record, Sean Grove, Deputy Executive Director, TJJD. One of the main issues, and I think this goes to Rep. Lauterbach's conversation on like the battery life. And so one of the issues with the former camera was that when that camera ran out of battery, which is, corrections is unique in the terms of using body-worn cameras, because even the occupations code for law enforcement officers and most policies and law enforcement agencies across the state and across the country is at the point of contact. So you're pulling over a car, let's turn on our body camera. Or when the lights go on, the body camera automatically turns on. Or I pull my duty weapon out of the holster, the body camera automatically turns on. Corrections, the purpose is to be running the whole time. And so for Axon, even the vendor, when we got body-worn cameras in 2018, to our knowledge at the time, we were the second largest correctional jurisdiction in the country with body cameras, second to Cook County, Illinois, Chicago. And so through that trial and error, we figure out what that battery life really needs to look like. And that helps with recording at lower clarity, the 1080p versus the 520. And that's the extent of my IT knowledge. But what the concern was is that when that camera ran out of batteries, we were so quick to try to get a new camera on that juvenile correctional officer that then the database wasn't being uploaded because we assigned a camera to one juvenile correctional officer. Now, with the capabilities with Axon Body 4 and how we're working with our vendor currently, there is an RFID chip that scans, and that then assigns the camera that the officer can use. And so in terms of continuity through malfunctions of the camera or turning off the battery or the battery running out, the new product that we have in all of our facilities will be able to ensure that we have that continuity of the body camera and we know the exact JCO that it's assigned to.
Any other questions?
Just a comment.
Okay, Mr. Clever.
We don't have time to go into all the problems that body cams have. There's some people out here in the audience that can. And I'll be more than happy to get those people to you. Thank you all.
Thank you, sir.
Okay. Anything else? If not, we appreciate y'all being here, and we'll give you a short break before you have to come back in front of the other committee. So thank you very much. Members, that concludes our, now, let me ask Mr. Cook, what's your plan? We've got about an hour till session begins.
We'll get started in 30 minutes.
Yeah, so 30 minutes from now, the committee on juvenile issues will convene here in this room. So thank you all. Anything else, members? If not, we appreciate all of you being here today. We'll meet again next week, and so the committee is adjourned.